Hello, everybody. Welcome yet again to this Heinz webinar. It's our regular deep dive into the weird, wacky, wonderful world of strata, body corporate, management rights, and all the associated bits and pieces that go with it. I'm Chris Irons, and I am director of StrataSolve. That's stratasolve.com.au. And right alongside me, as always, Frank Higginson, partner, Heinz Legal, premier provider of legal advice and services to the strata sector in Queensland. Hello, Frank.
Hello, Chris. Hello, everyone. So I suppose our fortnightly Thursdays now, not our weekly Thursdays.
Yeah. Good things come to those who wait, I suppose, is another way of putting that. Just another day in paradise, isn't it, Frank?
It is, mate.
Life chugs on for us all. Bit of housekeeping for everybody. It's always important to go over this. If you're listening live via YouTube, you can post questions in the chat. And I think, Frank, it's fair to say we welcome those. Try keep us on our toes. Get into it as much as you can, and we will certainly try and answer as much as we can also. But if you are listening to this a bit later on, like say as a podcast while you're walking the dog or doing the dishes or whatever, you can find all the notes and links that we referred to today at heinzlegal.com.au. So, Frank, this is a sequel webinar.
Yeah, we talk about our sequels all the time, and I'm going to, put my hand up and say we're not the very best at following through on them, but this one certainly is. So we did pets previously in relation to the new tenancy law reform, and it's fair to say we got a fair bit of inquiry, none of it paying, but a fair bit of inquiry from people afterwards about what does this mean and what does that mean and how's this going to work, and it's like, oh, good. I think you were the same, weren't you, mate?
Yeah, look, there was a huge response to that previous one, Frank. Some of the biggest numbers I think we've gotten for some time, which tells us that, tells us a few things, doesn't it? It tells us that there's a bit of confusion, a bit of anxiety out there. But I think that fundamental issue, and I know I've harped on about it a fair bit, you have too, Frank, that fundamental issue about the intersection between tenancy and strata. Not well grasped, not well understood. And then whenever there's something which comes along which has a big impact upon it, it's big interest, isn't it, Frank?
It is, and it's that occupier, the definition of occupier that everyone seems to forget, because strata, it really does come about owners and owners' rights and levies and voting at general meetings and all those sort of things. And there's talk that, New South Wales, I'm not sure whether they did it, having a tenant advocate on committees. I can't remember whether that happened or not. It popped up here in one of the agendas. But, and again, from a government perspective, clearly there's a desire to look after the rights of tenants. And we've seen that with pets, where in a sense, sort of tenants, I wouldn't say they've got more rights than owners, but they've probably got equivalent rights now in terms of the ability to keep a pet. And that's where the body corporate ties in. But what we're talking about today in terms of minimum housing standards, they're probably have more rights potentially than owners with respect to some of the issues we're talking about, which is really interesting.
Absolutely, Frank. So yeah, that's what we're talking about today. So the next big thing that's coming along for residential tenancies reform in Queensland, minimum housing standards. It's probably timely that we just very quickly reflect on our previous webinar though. And we've got a link up there for that, which is good. But just to remind everybody, that first webinar, which was about 80-90% about pets. So the general rule of thumb that from the 1st of October in Queensland, there needs to be a pretty exceptional set of circumstances for a landlord to refuse a tenant a pet, which is all well and good. But the issue, Frank, comes about because it's not going to be the same approval process for landlord and body corporate, is it?
No. So silence from a landlord means that pets are approved. Silence from a body corporate doesn't mean pets are approved. Mm-hmm. It might be a deemed refusal, which then allows you to go and have a crack at them in the Commissioner's office. But it's that, that's the issue more than anything else. And I suppose the other thing as we sort of spoke about in a lot more detail in the webinar, was that tenants still aren't necessarily going to understand that there might be a body corporate approval process and agents acting for them, or their landlords. On-site managers will probably know because they live in the scheme, they're dealing with the body corporate stuff, but outside agents might not necessarily be aware of the need to apply to bodies corporates to keep pets, and may be confused with the fact that landlords now can't say no, so why should a body corporate get involved? So, well, that's all going to be on in a month's time, so it's going to be super interesting.
And I think the timeframes are the other big thing there, Frank. As you said there, the landlord has 2 weeks to consider the request. Body corporate has 6 weeks, plus another 6 weeks in some cases, so up to 3 months potentially. Those two timeframes completely don't align. We think there's a high potential for the Commissioner's Office to see a pretty big run on applications, particularly intra-order applications. And just general kind of dysfunction, dispute, confusion. It's already a very difficult rental market in Queensland, as everybody knows, unfortunately. This is just one more ingredient in that great big melting pot. So that was the previous one. And since that time, I think, Frank, we spoke about how there was going to be a bit of education and information sessions being put out there by the Residential Tenancies Authority. Can tell you that since that previous event, the RTA have indeed announced several seminars and a webinar in Brisbane about this topic. You better get in quick though, because at least one of them, the last time I checked just before we did this, is already sold out. So you better get onto it. We're going to put the link up there. So we got nothing to do with that, but just go to the link, have a look. At some point, Frank, it was suggested the Commissioner's Office were going to be participating in those too.
Yes.
I'm not 100% sure if that's happening, but hopefully they are. Yeah. But, so that's that. Now let's talk about the next one, which is minimum housing standards. So these come into effect for new tenancies from the 1st of September 2023. And for existing tenancies from 1st of September 2024. So either a year or 2 years, depending upon where you're at. And so what? 2 years, Frank, who cares? Why are we talking about it now?
Because it's going to cause carnage when you actually sit there and look at the detail. And this is I suppose, and we're both part of the law reform process now in terms of the review of the Strata legislation, which is extraordinarily interesting in terms of trying to understand the unintended consequences and what might flow from particular decisions about laws. I'm sure, this was on the radar before COVID. COVID's a couple of years ago now, in terms of the intensity of all of that. But time flies. It's just going to be here before we can blink. And at that stage, and this is probably part of the problem with all of these things, it appears and everyone's busy doing what they're doing, and then suddenly, hang on a minute, here's this piece of legislation. What does it actually mean? So I suppose, to be fair, for once, we've got plenty of notice about it, what it's going to mean. And again, it's sort of a bit of it's not pro-tenant. One of the things, I suppose, one of the fundamentals from a property law perspective is in relation to tenancies. There's commercial leases, it's residential, it's everything, is tenants are entitled to the quiet enjoyment of the property which they're occupying exclusively, which is really what a tenancy is. So what a tenancy agreement gives you the right to do is to occupy that particular property to the exclusion of all others. So you shut the front doors, it's yours. And quiet enjoyment is you're not getting harassed, you've got reasonable living conditions, all that sort of stuff. And I suppose what the minimum housing standards to me are probably prescribing some of the things that might be considered quiet enjoyment, but probably from a legal perspective haven't necessarily been defined that way in the legislation. Now we're getting them.
That's right, Frank. Good summary there. I think the other point for everyone to remember is that things happen in the body corporate very slowly. And also things are done via a group decision-making process. And I think, if memory serves me, Frank, you and I were in the same meeting with the Commissioner's Office at one point very recently, and the staff, one of the senior staff there, was saying, well, we're turning our attention to this stuff now because it takes so long for a body corporate to get something done. to the point where I think that 1 year probably isn't going to be long enough in a lot of cases. But okay, what are we actually talking about then? That's probably where we need to move to next. So I'm going to put a link up to the legislation. Now, we stress this is not the legislation that contains the minimum housing standard. This is the legislation which contains the ability of government to make the minimum housing standard. So quick legislation refresher 101 for everyone. The Act gives the ability to do certain things, and then all of the prescriptive minutiae, that's a fair way of putting it, Frank, isn't it?
Yep.
All the prescriptive minutiae, it's in the regulation, isn't it?
It is. And if you're going to compare it to the BCCM Act, the BCCM Act says the module can make regulations about meetings. And so all of the detail about meetings and notices and what must go out with them, secretaries' roles and all that stuff is in the regulation module. So that's the same here, in the sense it's not going to be a regulation module, but it'll be a specific regulation that I suppose government over time can change to deal with whatever it is and add and subtract and whatever it might be. And I think probably the big thing for the purposes of today is the Act, what the Act says about what the regulation can dictate, I suppose, for want of a better phrase. And I think, Chris, I think it's worth running through these for everyone's sake.
I think it is too, yeah.
Because it's really important. Maybe we do them in
starting with... You kick off with A, Frank.
Yeah, cool. Sanitation, drainage, and the repair of the premises and the inclusions or facilities with it.
That could be common property and some.
It could
some.
be.
Okay. B, ventilation and insulation. Well, to me, Frank, that's very much about cooling towers and air conditioning.
Air conditioners, absolutely.
Yep.
Windows and blocking things. The next one, and we'll spend a little bit of time talking about this, protection from damp and its effects.
What could that mean?
Yes, water ingress and mould, but we'll get there with that.
Yeah. The next one, construction conditions, structures, safety and situation of the premises. Interesting. That can be interpreted, I think, pretty broadly, that one.
Absolutely.
To me, that's building defects, isn't it?
It is, absolutely. Cracks in walls, roofs, that sort of stuff. The next one, the dimensions of rooms in the premises. So that's how far down these things are going to be able to go. So now you'd think in a normal strata building, people haven't built rooms that aren't compliant with the existing planning code. That's going to be a condition of approval. Maybe that's related more to sort of share accommodation or that sort of stuff. Yeah. But it's interesting in terms of this is where the regulation is going to be able to dictate terms.
That will be a big one for new buildings, Frank. The next one, privacy and security. So what happens if the minimum housing standards prescribe a standard for security? That's absolutely an implication for the body corporate at that point in terms of CCTV, locks, fobs, security guards.
Yeah, swipes to get in and out of garages. Those sort of things break. Next one, it's again what the regulation can have, I suppose, comment on. Provision of water supply, storage and sanitary facilities.
Yeah. Maybe.
Oh, it's interesting. Hot water, cold water?
Yeah. Yep. The next one, Frank, is laundry and cooking facilities. I think we can safely say that one is very specific towards a boarding house or rooming accommodation. So maybe not applicable for strata.
Yep. Lighting.
Absolutely.
Full stop. That's. Are we talking hallways? Are we talking common property? Are we talking garages?
The next one, freedom from vermin infestation. That's a huge body corporate issue, that one. So just imagine, and we will spend a little bit of time on that one in a minute. If that means termites, if there's a minimum standard about freedom from termites, I think, Frank, you'd be well aware of how contested issues around termite infestation are.
Absolutely. So termites, vermin, ants, vermin, rats are certainly vermin. It's pigeons are vermin. Flying rats, aren't they? Pigeons. And then the last one, And I suppose here we go on the green side of things, energy efficiency.
Right.
So there, I suppose, what are we, A through K, in terms of what the Act says, the regulation can provide rules around. So, and if we don't have the detail yet of what that's going to be, I suppose we don't know what government's going to do. But in terms of, yeah, and you would look at it and say, from a tenancy perspective, all of those things aren't unreasonable to make sure that when you're renting somewhere, you've got drainage, you've got protection from damp and effects and all that sort of stuff. And in a house, maybe, and this is the thing we're getting to, because in Strata, quite a few of those things aren't necessarily individual owner decisions, are they? They're body corporate issues.
They're definitely not, Frank. Yeah. So just to clarify for everybody listening, so that A to K are the standards which are possible. We don't know for sure if all of them are going to be included, and we don't know the detail of any of them. They haven't been prescribed. There's been no consultation on them. So you could have all of them. You could have a couple. If I had to speculate, I would say there would be no point having those standards written in there if they're not going to be prescribed, all of them. It just doesn't. And the way in which housing issues are pretty hot button issues at the moment, I'd be surprised if all of them were not included. Frank, what do you think?
Agree. What's the point of naming them if you're not going to address them?
I think
like,
that's it.
You know, like the, yeah. Oh, we just put a couple in for extra in case we thought we might need them. No. They'll be very specifically.
I would have thought so. So let's look then, for example, let's take a couple of an example. The one, item C, protection from damp and its effects. So I think, Frank, you and I are agreed this is probably mold, isn't it?
It's water and mold. It absolutely has to be. So, you know, and we still get an enormous amount of inquiry in relation to both of those things. Like, I've literally just finished drafting a circular for a body corporate committee who's got a general meeting coming up about a whole bunch of spending to fix water ingress issues. But that's been that process has been a couple of years in the making, because it takes time. You know, this is a high rise. There's a bunch of different issues you've got to take into account, et cetera, et cetera, et cetera. So from a body corporate perspective, I think that committee has done what they should be, and they've acted appropriately. They've investigated, they've got expert opinions, all that sort of thing. But, and I suppose this is a really interesting thing in terms of, you know, I suppose ideologically you would say, is that the owners in that building have had to ride the wave of dealing with it, taking time, going through the process, all that sort of stuff, you know, the committee, the owners, all that sort of thing, and some of them live there. But what this, I suppose, prescribed standard is going to bring into account is that if a unit that is tenanted is leaking or has mould, the tenant, in effect, is going to have more rights than the owner to have something done about it. And I suppose what might that something be? Is to terminate the tenancy, is to take action against the landlords, whatever it might be. Let's leave that out of it for the moment. But if the regulation says that you're entitled to have a roof that doesn't leak, and this body corporate's taking 2 or 3 years to go through the process to identify the source of that leak, and then the process to fix it, and then raise the special levies and have all those sort of things, how are those two things going to interrelate? And I suppose, mate, that's what we're talking about today. That's another differentiation of rights and responsibilities. We were talking about pets last week with tenants and owners. It's going to be the exact same thing with tenants and owners in relation to the right to occupy a particular premises.
And just to pick up on all of those points, Frank, you've got to remember that here we're talking about residential tenancies legislation requiring these things, not body corporate legislation. Residential tenancies legislation carries a much bigger stick than Strata legislation. There are indeed, where I'm always fond of talking about body corporate police. There are none of those, but there are certainly residential tenancies police out there. So there will be, and the other thing we should probably mention is that regulation, in addition to all of those standards, will also include information about penalties and enforcement. We have no idea what they will be, but again, I suspect they'll be significant. So you can end up with a scenario potentially in which a minimum housing standard requires the owner, the landlord, to ensure a particular standard for the occupier, but it is at least partially a body corporate responsibility to do that, but the onus will be upon the landlord to do it in the first instance. I think we're still waiting to see how that, as you say, Frank, that interplay will get addressed.
Yep, and that's going to be massive because usually water ingress is not an owner problem.
Yep.
It's coming through a membrane somewhere, particularly in high rises, and that's a body corporate issue.
So you can see where it's changing potentially quite dramatically, the responsibilities here. Let's take another example out of that list: energy efficiency. That's a good one. Could mean a whole bunch of things. That might mean solar panels. Fine. There's already a few provisions in relation to solar panel installation in Strata. Maybe, Frank, it might even mean EV stations.
It's lurking, electric vehicles, and it's sort of how you retrofit buildings and whether councils are imposing new rules in relation to putting new buildings and availability and all that sort of stuff. But again, this is another massive issue, I suppose, in the sense of if a minimum housing standard is that you must have the availability of electric vehicle charging at some stage in some way, you're going to have to hopefully the government deals with it in the sense of, for a strata though, there's a different set of rules, because it's not just a matter of plug and play, for want of a better phrase. It's straight away, it's a special resolution, it's prove it a common property. It's how do you get the right, if it's in a visitor space, how do you get the right to park and use it? Is there a booking system? If they're in individual bays, where's the infrastructure come from and go to? How does the body corporate recover the costs from the individual users in relation to electric vehicles? So it's a very messy thing at this point in time from a body corporate perspective. But you're right, if the government mandates, who knows, a percentage, a style, a certain number of these things per building, it's going to be extraordinarily difficult to deal with from a legal perspective.
Absolutely, Frank. And I think the other interesting one there is that one about security, privacy and security. I mean, that minimum standard could be massive for a body corporate, particularly if the standards start to differentiate between different kinds of buildings and different kinds of locations. I don't know if they would, but they might. That's going to start to produce a lot of interesting results, I would suspect. We've got a couple of questions there that I wouldn't mind getting to. We'll get to those in a tick. We might just do our usual best practice thingamajiggy. So I think the challenge here for everybody is that this all is a bit of an abstract discussion because we don't quite know what we're doing with. And I think one of the challenges about abstract discussions is it's very easy to switch off of them, disengage. I'll worry about that later. I think our point, Frank, is no, you probably should start to worry about that now.
Yes. And really, to me, I'm reading this as, and this is, again, one of the difficulties with Strata is that preventative maintenance program will get ahead of things as opposed to reacting to things. It's how a lot of bodies corporates operate. And that's the reality. So I get it. People are volunteers. They're trying to find alternatives. They're usually, they've got other things in their lives beyond creating their body corporate to be the best it can possibly be, like their own families or jobs or investments or whatever it might be, bowls on a Tuesday night. But I think from a body corporate perspective, if you're not ahead of the curve in terms of making sure at least your facilities are all under control, and particularly around stuff like mold and all that sort of stuff and water ingress, there's going to be some pain coming if you ignore things. So if there are common property defect issues, my take would be this is really a bit of a call to start getting ahead of them now.
I think that's right, Frank. Yeah, definitely. And I think the other thing here is that you need to stay on top of the changes that are coming through. So, make sure you're subscribed, whether it's to ourselves or to the RTA or BCCM or all of the above. is probably the ideal. You don't want to miss out on when the announcement is made, just in case there is something quite specific that you'll need to be aware of. I think very closely related to that, Frank, if I may, I think it's also about just keeping an eye on the political landscape here as well. Where this whole discussion represents a really interesting kind of nexus between or amongst housing policy, residential tenancy policy, strata policy, building policy. Somewhere that, if you imagine that Venn diagram of all of those things intersecting, there's going to be this bit in the middle where this is where it all comes together at one point. And then over here, you've got that political ideology, you've got this political ideology, you've got this other political ideology, which is very strong in the inner city. And there's an election not too far away in Queensland.
You are such a legislation geek.
You just got to keep you just got to sort of understand what the motivations are here, Frank. Yeah.
I know there's a lot of moving parts, and like even for me as a lawyer trying to stay on top of it all, it's just like I'm looking at that saying in 12 months' time, or probably 18 months' time, realistically, legislation commences 6 months later, the wheels start falling off certain things. That's going to be potentially extraordinarily busy. I mean, I said the same thing about cladding. Cladding didn't turn into all the legal warfare that I thought it might have, but that was a big thing at the time, and that's probably because the market accepted it and just got on with it. This might be something different. I don't know, but there's a lot of change happening at the moment.
There is. Let's get to a couple of questions, Noel. Thank you. An interesting one, Noel. We have 52 lots. One occupier asked to keep ducks. We, the committee, said no. After the 1st of the 10th, do we still have the right to say no?
Well, here's an example of how this stuff gets confusing. An owner-occupier isn't subject to the tenancy regulations we've been talking about. And I think it's going to come down to a question of pets. Can ducks be pets? I suppose they can be pets.
Huh?
You know, I mean, I suppose we've got emotional assistance turkeys, don't we? And all that sort of stuff that go on planes with people. So maybe.
Noel, I'd be wondering what your bylaw says you can and can't do. And then also what reasons you gave. If one of the reasons you gave was ducks are stupid, then that's probably not going to cut it. If there's some other quite reasonable involved reason to it, maybe. I'd think that there'd be at least a little bit of doubt about that decision at this point, Noel, that you've made. That's just me, though. Sam, thank you. A building with CCTV cameras in all level foyers and entrances and common areas such as a pool and outdoor area, would this be breaching tenants' privacy? I think so.
No, it's not. And I suppose the interesting thing to me in terms of what the regulation might say about privacy is there a right to not be monitored by cameras and that sort of stuff? That could be interesting, as opposed, and the same as they could have an obligation to provide security. And I suppose, Chris, back to what you mentioned before, if you've got a high rise in Central Surface Paradise versus a townhouse estate at Callumvale, the security needs are probably different. So, yeah, how those differentiate will be really interesting.
Very true. David, I know you're becoming a bit of a regular. Thank you. For a tenant with a lease of 6 plus months in a standard module scheme that is not on the roll, and remember section 2231B, thanks, David, where do they stand in dealing with the body corporate under the new tenancy laws? So I guess my initial response, David, is they still have the rights of an occupier, regardless of whether they're on the roll or not.
Would agree. Absolutely agree. So just because you're not on the roll doesn't mean you don't own the property or you don't have the right to reside or you're not a tenant. I suppose an appropriate response from the body corporate to a request from someone that's not on the roll would be, well, who the hell are you?
Yeah, exactly.
Oh, well, I've got a lease in lot 23. Well, would you mind updating the roll? And sure, now let's talk.
Yeah, exactly. But I think, David, if you're asking the question, does the body corporate have the right not to talk to someone who's not on the roll, even though they're 6 months or more? No, not under those circumstances. They don't. Whew, gosh, they're tricky ones. And we've come to the end today. That's all we have time for. This time around, you can find all the notes and links we've mentioned at heinzlegal.com.au. You can find me, that's Chris Hines, at Strata. You can find me at stratasolve.com.au. You can find Frank at hineslegal.com.au. Another good session today, Frank.
Yes, mate. So in 2 weeks' time, we're going to be delving into two lot schemes, because there's the biggest number of bodies corporate in Queensland, and a very, I suppose, what would you call it, untrodden conversation point. There's lots of really intricate things with two lot schemes. So if you're interested in those, your duplexes, come along.
But again, thanks everybody for tuning in. It's always appreciated. Thanks very much. See you next time.
Bye.